Welcome to another deep dive using the materials you've shared with us.
Great to be here again.
Today, we're tackling a really classic legal puzzle, aren't we? The contract and restraint of trade.
Absolutely. Those clauses you see trying to stop someone working somewhere else after a contract ends.
Yeah, they pop up all over employment contracts, selling a business, and figuring out if they actually hold up in court. Oh,
Yes.
that's a crucial skill.
It really is. And for this deep dive, we're going to use that case study. You've got Quantify Solutions Limited and Sarah.
Right.
The idea is to use this specific scenario and the legal points from your materials to kind of walk through how you analyze these things.
And importantly, how you'd actually go about answering a law exam question on it.
Exactly. Consider this our guided tour using the source materials.
Okay, let's get into it. Let's unpack Quantify and Sarah and the law behind it.
So, first things first. The materials tell us these restraint of trade contracts are basically agreements where one side says, okay, I won't do certain kinds of work or trade, usually after things end.
Like stopping an ex-employee joining a rival, or preventing someone who sold you their shop from opening a new one next door.
Precisely those situations. And the starting point, the general rule your sources mention, AsiaWorks Global Investment Group Private Limited, and Ismail bin Sayed Mod here, is that these clauses are, by default, void, unenforceable.
Which makes sense, right? You want people to be able to compete fairly. You can't just lock someone out of their profession forever.
Absolutely. The law leans against them.
Yeah.
But, and this is the really interesting part, that void status isn't absolute. A restraint can be enforced if it's shown to be reasonable.
Reasonable. Okay, what does that mean in legal terms?
It means reasonable looking at the interests of the people involved, the parties themselves, and reasonable from the public interest point of view.
Got it. And the materials highlight two main places these pop up. Employment contracts, like our case study, and when a business is sold.
Yes. Now, there's also the Competition Act in Singapore dealing with anti-competitive stuff, but we're going to focus here on the common law test from your materials. That's what we need for Quantify and Sarah.
Right. And that common law test, it boils down to three conditions, doesn't it? Three things the restraint has to meet to be valid.
Exactly. We need to look closely at these three criteria.
Okay, criterion one.
Protection of a legitimate interest.
So the person trying to enforce the clause, quantify in our case study, the employer, they have to show they're protecting something real, something legitimate, not just stopping competition.
That's it, precisely. You can't just stop someone competing because they're good. When selling a business, the main legitimate interest is usually goodwill.
You mean like the business's reputation, its customer base, the brand?
Yeah, basically the established value and connection with customers that the buyer paid for. But in employment contracts, this is a bit different. Employers can't stop former employees using their general skills and experience.
So what can they protect?
Typically things like confidential information, trade secrets, special formulas, that kind of thing, or specific trade contacts, like client relationships the employee built up because of their job.
And your materials mention some cases here, like Asia Business Forum Private Limited and Long Island and another, like
Yeah.
Noi and Humming Flowers and Gifts Private Limited.
And Tan Cook Young Steve
Ah.
and Itochu Singapore Private Limited, yes.
Yeah.
Those all support trade secrets and contacts as legitimate interests.
Okay.
And there was that interesting point in Man Financial S Private Limited and Wong Bart Chuan David, where the Court of Appeal suggested protecting a stable, trained workforce could sometimes be a legitimate interest, maybe justifying a clause preventing poaching of other staff.
But, and this seems really crucial from the materials, citing cases like Herbert Morris Limited and Saxelby and Buckman Laboratories, Asia Private Limited and Li Wei Hong.
And reaffirmed in Stratex Systems Limited and Niam Chushin and others.
Right. The point is you cannot use these clauses just to stifle competition from an ex-employee using their general know-how.
That's the absolute key distinction. The court won't help an employer just because a skilled former employee might compete. It must be about protecting something specific the employer owns or developed, like secrets or client lists, not just the employee's own abilities.
Okay, so hurdle one, a genuine legitimate interest beyond just preventing competition. What's the second criterion?
Reasonable scope.
Yeah.
And this is often where the real arguments happen.
Scope, meaning how long it lasts, where it applies, and what exactly it stops them doing.
Exactly. Duration, geography, and subject matter. And the core idea, you see this in Man Financial S Private Limited and Wan Bark Chuan David, is the restraint can go no further than what is necessary to protect the interests concerned.
Minimum needed, nothing more.
Precisely. So duration, is it too long? There's no fixed rule.
Yeah.
TLAS Medical Center Private Limited and Eng Boon Ching found 3 years reasonable in its specific facts.
But that was quite specific, wasn't it? About the doctor's prominence and things.
Very specific context, yes. Other cases, like Esso Petroleum Company Limited and Harper's Garage Stourport Limited, looked at different lengths. It depends entirely on what you're protecting and how long that protection is genuinely needed.
And geography. That seems like it could easily be too wide. The materials mention some examples.
Oh, definitely.
Yeah.
Basin and Provident Clothing and Supply Company Limited is the classic example. A 25-mile radius was way too much for a canvasser working a small area.
Right.
And clauses trying to cover anywhere in the world are almost always struck down unless it's a truly global business interest. The geography has to match where the employer's interest, the secrets or clients actually needs protection.
Makes sense. And the third part of scope's subject matter, what activities are banned?
Yeah, what exactly is the person restricted from doing? HTSRL and Wishua Woon says there must be a close link between the restriction and the employee's actual job. And that KLA's Medical Center case is great here too. They found the duration and geography, all of Singapore, reasonable for that doctor. But the subject matter, aesthetic medicine, was too broad because it covered things the doctor didn't even do there. It wasn't tailored enough.
So it went beyond protecting the clinic's actual business he was involved in. The scope needs to be really tightly defined.
Then there's the third criterion, public interest.
This feels a bit broader, like a policy check.
It is, essentially. The restraint shouldn't harm the public. Your materials mention Asia Polyurethane Manufacturing Private Limited and Woon Sa Lying. It could be an issue if the restraint messes up trading arrangements significantly or maybe reduces competition in a way that hurts consumers.
Like that Esso Petroleum case again, where tying up petrol stations for 21 years was partly bad because it restricted public choice and competition.
Exactly. But generally speaking, the courts tend to focus much more on whether the restraint is reasonable between the two parties. Unless the employer is hugely dominant in the market, or the restriction would clearly harm the public significantly, this third limb is often less decisive than the first two.
So the main fight is usually over legitimate interest and reasonable scope.
That's usually where the analysis focuses, yes.
Okay, so we have the three tests. What happens if a clause fails? If it's unreasonable.
The materials are clear, it's void, unenforceable, gone.
So in our case study, if clause 15 is unreasonable, Quantify just can't stop Sarah.
As written, correct.
Yeah.
But there's a doctrine the courts can use called severance, sometimes called the blue pencil test.
Severance, meaning?
It means if part of the clause is unreasonable, but you can just strike out that bad part, like literally cross it out with a blue pencil, without changing the basic meaning of what's left.
Then the court might just enforce the remaining reasonable part.
Exactly. They don't always have to throw the baby out with the bathwater.
Yeah.
That key LAS Medical Center case, again, they struck out the overly broad definition of aesthetic medicine.
Right, the and all procedures bit.
Yes. They severed that phrase. And what was left, restricting the practice of aesthetic medicine in Singapore for 3 years, that was found reasonable and enforceable.
So you can save a clause if the unreasonable bit can be neatly cut out without needing to rewrite the whole thing.
That's the essence of it. You remove the offending part, you don't rewrite the deal for the parties.
Okay, brilliant. That's the legal framework from the materials. Now let's apply it step by step to the Quantify Solutions Limited and Sarah scenario. This is really the core of how you'd tackle a problem question.
Exactly. First step in your answer. Briefly state the key facts. Sarah, skilled developer at Quantify, access to sensitive stuff algorithms, client lists, plans. Clause 15 in her contract. 2 years, Southeast Asia, no development, marketing, or sale of financial data analysis software. Leaves, joins competitor in Singapore.
Okay, step 2. State the issue. Clearly the issue is clause 15 enforceable against Sarah?
Perfect. Step 3. Lay out the rule. You'd explain the general rule prima facie void, the exception enforceable, if reasonable. Then list and briefly explain the 3 conditions: legitimate interest, reasonable scope, public interest, and crucially, mention severance. Cite the key cases from the materials for each point.
Right. Now, step 4, application. This is where you dig into the facts of Quantify and Sarah using those rules.
Yes, let's take the criteria one by one. First, legitimate interest. Does Quantify have one?
Well, the facts say Sarah had access to proprietary algorithms, confidential client lists, future plans, client relationships. That sounds like the stuff the cases recognize.
It does. It fits squarely into protecting trade secrets and trade contacts, like in Asia Business Forum and Long A Sin and another, or Lick Guinoy and Humming Flowers and Gifts Private Limited. It doesn't seem like they're just trying to stop her using general skills.
So Quantify likely does have a legitimate interest to protect here. First hurdle probably cleared.
Agreed. It looks like it.
Okay, on to the second, and often the crunch point. Reasonable scope. We need to look at Clause 15's terms carefully. Duration first. 2 years.
How does 2 years feel? Well, we saw TLA allowed 3 years in its context. Tech moves fast, yes, but financial algorithms and client relationships can have a lasting value. 2 years.
It doesn't immediately scream unreasonable. It's certainly arguable it could be okay, given the sensitive information.
Plausible then. But now, geographical scope. Anywhere within Southeast Asia.
Now this looks like a problem, doesn't it? Based on the materials in cases like Mason?
Yes, Sarah's joined a competitor in Singapore. Quantify is in Singapore. How can they justify stopping her working across the whole of Southeast Asia? That's, what, 11 countries?
Exactly. Quantify would need to show their secrets or client contacts are genuinely at risk across that entire region. Based only on the facts given, that seems like a huge stretch. It almost certainly goes further than necessary to protect their interests in Singapore, where the competition is actually happening.
So that part is likely unreasonable. Very likely, yes. That geographical scope is probably fatal to the clause as it stands.
Okay. What about the subject matter scope? It restricts development, marketing, or sale of data analysis software for the financial sector.
Right. Sarah was a developer. Restricting development seems directly linked to protecting their algorithms and plans. That makes sense.
But what about marketing or sale? Is that necessary?
Maybe, maybe not. Quantify would have to argue her development knowledge gives her an unfair advantage in marketing or sales, or that her client contacts were relevant beyond just development work. Without more facts, adding those activities could be seen as wider than necessary.
And the financial sector, that's broad too. Like we saw in CLAA, the activity restriction needs to be linked to her actual work. Was she involved in data analysis for all parts of the financial sector, or a specific niche?
Good point. If her work was more specialized, restricting her across the entire financial sector might also be too broad. So aspects of the subject matter could be problematic too, though perhaps less obviously than the geography.
Okay, so scope looks like the weak point. What about the third test? Public interest.
Well, you could argue stopping a skilled developer like Sarah working across a whole region for 2 years isn't great for innovation or competition in fintech.
But as you said, the courts usually focus more on the parties unless there's a big market impact.
That's right. The materials suggest it's less likely to be the deciding factor here compared to the scope issues, unless Quantify was shown to dominate the market, which isn't mentioned in the facts. You'd mentioned it briefly, but focus the main analysis on scope.
So, bringing it together for Clause 15 as written, legitimate interest seems okay. Duration might be okay. But the geographical scope is almost certainly too wide, and the subject matter might also be too broad.
Meaning the likely conclusion is that Clause 15, as drafted, is unreasonable and therefore void, unenforceable.
Right, but that's not the end of the story for the exam answer, is it? We need to consider severance.
Absolutely. Step 4B, if you like, discuss severance. Can the bad bits be cut out?
Could the court blue pencil out Southeast Asia, maybe imply Singapore instead, since that's where the action is?
That's a very plausible argument Quantify could make. Severing the geographical term seems possible without fundamentally changing the clause, following the logic in Tulare A. Limiting it to Singapore makes it far more likely to be reasonable.
What about severing marketing or sale, leaving just development?
Also seems possible. If the main worry is her using the algorithms, just restricting development might be enough, and severing the other activities wouldn't rewrite the core promise.
Narrowing the financial sector might be harder.
Potentially harder, yes. That might feel more like rewriting than just deleting. But you discussed the possibility.
Okay, so step 5 is the final conclusion.
Yes. You'd summarize. Clause 15 as written is likely void due to unreasonable scope, mainly geography. However, Quantify could argue for severance. If the court allows severance, say, limiting it to development work in Singapore for 2 years, that severed version might well be found reasonable and enforceable. But it depends on the court agreeing to sever and finding the result reasonable.
That makes perfect sense. It's that structured approach. Issue, rule, application breaking down each element, considering things like scope and severance, and then a clear conclusion. Using the case names from the materials throughout is key too.
Exactly. Don't just state the rule, show how the facts fit the rule, using the cases as your evidence. Like saying, the Southeast Asia scope seems too wide, much like the overly broad area in Mason's case, or severance might be possible here, similar to how the court severed the wording in CLA. Referencing the materials anchors your points.
It shows you're not just guessing, you're applying the law you learned from the sources.
So that really unpacks the Quantify and Sarah scenario using the principles from your materials. You see how it's a methodical process.
Yeah, you take the general rules, apply them carefully to the specific facts, consider the nuances like severance, and build your argument step by step.
And that's precisely what these kinds of questions are, testing your legal reasoning, applying principles from case law to a new situation.
Thinking about this whole process, what's one thing you think students should really focus on when they first look at a restraint of trade clause in an exam scenario? What's the immediate trigger point?
For me, it's almost always drilling down into that reasonable scope element. Is it truly necessary, or is it trying to do too much? That's often where the clause lives or dies.
Great point. Well, hopefully that walkthrough was useful.
Happy studying. Until the next time we dive into the materials.